We are here in the matter of In Re KG. Each side will have 15 minutes in which to present your arguments. Appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, please let me know how much time you wish to reserve or when you begin your argument. I'll do my best to monitor the clock for you and try to keep you apprised of your time. The arguments are being visually and audibly recorded to be posted online. Please keep your voices up. Normally, I tell you to remain behind the podium, but different situation. Although we have had people who haven't remained behind the computer. I think you both know, don't use the name of the child who's involved in this matter. We have read your briefs. We are ready to begin when you are. And Mr. Aldridge, I believe you will start us off here today.
Thank you, Your Honor. I would like to reserve five minutes for rebuttal if necessary. And Your Honor, as the briefs, pretty thoroughly state, the main thing I kind of want to just drive home the point is the issue of the rebuttal. As the transcripts show, and both parties did brief pretty thoroughly, that we had a two-day trial that had numerous witnesses, hours upon hours of testimony, and at the bitter end, when paternal grandmother had requested a brief time to rebut certain issues, she was denied that time. And frankly, at the time, it appeared that the major consideration was getting the appellee onto an airplane that he had booked. Stepping back to the legal issues, because acknowledging that this is an issue that is generally within the discretion of the trial court, I would just like to point out that the issues that had come up during appellee's testimony were very much the issues that rebuttal testimony is designed to bring up. Just to draw the court's attention again to a few of the specific issues. When the paternal grandfather was testifying, he brought up numerous issues from when the parties as parents were executing a parenting plan, and how that affected certain decisions he made. He offered up what he stated was the opinion of third parties, one being the maternal grandfather. This was a person whose opinion hadn't been brought up in the slightest before. There was no way to know that this was going to be an issue. I think it was telling that he had brought up what he believed to be the father, his son's opinion, and the opinion that he stated to the court at that time was not the opinion that the guardian ad litem had made, not the opinion that his attorney had put out there previously in the case. And these are things that maternal grandmother never had a moment, or never had the opportunity to say, well, that's not how this happened 10 years ago, as far as how the parties did a parenting plan when it involved their son. Didn't have the opportunity to come back and say, no, I've also communicated with these people. That's not what was said. That's not what they told me. Again, this testimony that was offered falls squarely into new facts that were for the first time introduced by the adverse party. That's right down to the core what rebuttal testimony should have been permitted to bring up. Again, we'll concede that that this is an issue that is within the discretion of the trial court, but this owns court's precedent does generally favor allowing rebuttal testimony when these specific issues do arise. In this case, the paternal grandmother was denied the opportunity to address these issues, and it seemed like there was more concern about scheduling at this point, and it otherwise tainted what had been probably about 12 hours of testimony at that time. Probably would have needed less than a half hour to address some of these issues. And on top of that, I would say that the issues that we sought to rebut at the time, ended up not being harmless issues. You know, these communication issues were specifically addressed, you know, in the magistrate's decision. You know, one that I haven't brought up in this morning was, you know, our grandfather for the first time raised these issues about the times when the parents were, you know, first having problems of their own that led to this case. You know, in his opinion, that grandmother was enabling them and not addressing the issues. You know, this was another thing that came out of left field, and she didn't have the opportunity to address. And without that opportunity to address, it's not on the record, but I can tell you she has a very different recollection. She's a very different recollection of how that went down. And of the 4 items that were specifically addressed in the in the magistrate's decision, that was front and center. One of the reasons that the magistrate tilted a certain way on this, and I feel that would have made a difference if she would have had the opportunity to, you know, to respond to that. And again,
Counsel, I have a question for you. Without trying to sound, I don't know, snarky or whatever, how are we to know that at that time during trial, those are the things you wish to rebut? If that question makes sense. I mean, is there some conversation on the record about that? I understand you'll agree with me, you didn't proffer. Is that a fair statement?
Did not proffer. No, there was conversation on the record. We made an oral motion to the magistrate at the time to rebut. There was a back and forth about it. What exactly issues wanted to rebut.
Okay.
You know, at that time she, you know, said basically, you know, I had suggested that there were a couple dangling issues out there, a phrase that I regret because it's shown up in everybody's brief, my dangling issues. But, you know, and she responded, there were always going to be dangling issues. And, you know, respectfully, I will agree with that in principle, but, you know, these probably went beyond my poorly phrased term there, you know, because, again, in the magistrate's decision, these did become front and center. As far as the second and third assignments of errors, I'm pretty comfortable deferring to what the brief said. I'll just draw really very brief attention to our opinion that that some of the issues that the trial courts relied heavily on were issues that frankly didn't even seem to be very much in dispute between the parties. There was no nobody seemed terribly upset over booking the wrong plane. Even the adverse party agreed that wasn't a huge deal. Same thing with having my client's husband pick up the child. You know, that was something that was mentioned, but even the adverse party, the guardian ad litem, children's services, all said that this wasn't something that was terribly important. I believe the adverse party just said it was a surprise, but nothing that really raised his hackles up too much. So beyond that, I would just submit on those second and third assignments of error. I'll rely on what was written in the briefs, and I have nothing. I'm sorry.
I said okay.
Nothing further right now.
Ms. Green, whenever you're ready.
Thank you, Your Honor. May it please the court, in response to appellant's arguments here today, specifically with regard to the rebuttal, the appellant is correct in that this court does have some precedent with regard to calling rebuttal witnesses. However, the case law that he supports or has in appellant's brief, most of those cases are with regard to either a capital murder trial or expert witnesses, which here does not apply. As you can imagine, if you have competing expert witnesses and one expert is then not allowed to testify because of a pretrial ruling, that would substantially prejudice a party. Here, that is not the case. The appellant was not substantially prejudiced by not being able to call herself as a rebuttal witness. As the court had questioned, and one of the things we pointed out in our brief is that no one knew what the appellant wanted to rebut. at that point because there was no proffer. However, I don't think it would be a surprise to anybody that with regard to the parents' wishes, if my client said, Dad wants the child to come with me, the grandmother's going to get up and say, no, that's not what he said to me. These aren't two expert witnesses going at each other. They're divorced grandparents to this child. The wishes of the parent, as we point out in our brief, is a best interest argument. It is a best interest under 310904 F1A is the very first one listed, wishes of the parents. So that issue should have been reasonably anticipated by the appellant and presented in her case in chief. This was a unique situation in that this child was removed by Children's Services. Typically, Children's Services takes a stance in a case like this when we come to a sunset disposition and we're trying to get permanency for a child. However, in this case, unfortunately, they decided to remove themselves from the situation and remain neutral, which then basically made this a private legal custody matter. So the only issues here at this stage at a juvenile court proceeding with regard to legal custody is best interest. The appellant at the lower level, our position is, didn't even preserve this issue for appeal, made one brief statement in their brief, I'm sorry, excuse me, and only really touched on facilitation of communication. As the court can see under 2151-41D, and then the statute I also cited, 3109, there are several best interest factors which the appellee addressed in our case in chief. These two individuals had their time to put on their case in chief. Appellant was first in time, so they got to proceed. Those are issues that should have reasonably been anticipated, and they should have been prepared to present the testimony on those issues. Specifically, I want to address the things that appellant has brought up this morning with regard to the co-parenting issue that appellant is asserting that was something that the court heavily relied on. We disagree with that assertion. The magistrate's decision and then the court's adoption of that decision does not allude at all to their ability or inability to co-parent when the father of this child was small. We did present testimony on that, just as to, it does go to the ability to communicate and facilitate communication. However, that issue was not brought up first under our case in chief. Grandmother was questioned while she was a direct witness for herself, was cross-examined by myself, and I can point the magistrates to pages 268, 269, where, oh, I'm sorry, wrong pages, 151 to 152 and 185, where she was questioned on cross during her case in chief by myself. So that is not an issue of first impression that came up in our case. The magistrate also did not allude to any enabling behaviors. What the magistrate was pointing to in her decision was that the 2017 issues where grandmother knew of them and didn't act on them. That is not enabling behavior. That is not what the magistrate was alluding to. She was alluding to the fact that she had concerns that this grandmother could provide a safe environment for the child and could act in best interest of the child with regard to his safety. So we would argue that that is a misplaced argument and a mischaracterization of the court's decision. And with regard to the other issues as far as the plane and not getting back on the plane on time and the exchange, not communicating for exchange, I'm not sure which adverse party the appellant is referring to, but we did present testimony and evidence that the appellee did have serious concerns about that and about how that would impact this child long-term, those failures by grandmother. Lastly, I want to address the appellant's assertion that my client's need, or the appellee's need, I'm sorry, to get on a plane at the end of this hearing had anything to do with the failure of the court to allow his rebuttal witnesses. It's simply not supported by the record. The record shows that, yes, we mentioned that he had a plane to get on. However, he stayed for the guardian's report, testimony, and all the cross-examination that went along with that by 5 different attorneys, several attorneys. He only left, I believe, right before closing statements. So to say that it was at all had anything to do with his schedule and catching a plane is just simply incorrect. You know, we feel that the appellant has argued that this decision is against the manifest weight of the evidence, which this court knows means that the judgment is clearly unsupported by the evidence and another outcome is obviously correct. That is not the case here. The case is that the judgment is clearly supported by the evidence and there is not another outcome that is obviously correct. So we would ask the court to affirm the lower court's ruling that this child remain in the legal custody of the appellee and in his best interest. Thank you.
All right, thank you. Mr. Aldridge, you have your full 5 minutes for rebuttal if you wish to take it.
Thank you, Your Honor. Don't think I will need 5. Just a few points from Ms. Green's comments. You know, she mentioned this court's precedent, and I would suggest that that precedent is in no way inherently limited to expert witnesses or capital murder trials. You know, I know that in reality, certain cases are going to be considered "quote unquote" more important than others, but that's not something that is brought up. That decision could have been limited to criminal matters, could have been limited to certain types of matters. It's just not. It's a general guideline for the courts and on how to treat rebuttal witnesses. And if if any particular court wants to put additional restrictions on it, they certainly have that right within the guidelines set by that precedent. Would also suggest, and maybe I didn't speak clearly enough, but when I speak of the enabling issues, the term that I used was I did refer to sort of these issues raised in 2017 that grandfather had brought up as far as what was going on between the parents and the grandmother at that time, and while there was some testimony about that, he really dug into certain specifics that she didn't have the opportunity to review. And if I had to say that there was one central one that probably needed to be addressed, that would probably be it. Now that is with a little bit of the benefit of hindsight, knowing that was item number 1 in the magistrate's decision. But that's the one that does lead me to believe that we may be looking at a different outcome if she would have had the opportunity to not just respond to questions about it, but to also have the opportunity to respond to grandfather's particular testimony about it. Again, I feel that kind of is the central one. Although I do continue to assert that there were other areas that she would have reviewed it at the time. I think a review of the record is going to show that there was an exchange between counsel and the court as far as what was expected to be reviewed. It wasn't some loose end. She's going to respond. There were questions about what the testimony what the testimony was expected to be, how long it would take. There was that review before the decision to not allow the rebuttal testimony was made. I would ask the court to, in considering all these things, to reverse the decision of the trial court. Thank you.
All right. Thank you both very much. We will take the matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and on the website of the Supreme Court.